Okay, it's 12:02. Thanks everyone for coming. We should probably get started. Hey everyone. Thanks again for coming to our event. This is by popular demand. It's our webinar series for immigration related questions. I have the pleasure of being the moderator for today's event. For those of you that don't know me, my name is Anand Sampath. I'm the Assistant Department Manager at Baxter and Woodman, and I'm also the Treasurer at IAACE. Before we get into the details, what I did want to mention to all the audience is there is a chat box on your lower right. If you have any questions as the event goes on, feel free to drop those questions and we'll make sure to kind of assess them as time permits in the last 15 minutes of our session. So when you are putting the chat, make sure you send a message to everybody and not just a particular person. And now, with great pleasure, I want to introduce Laureen Anderson to our call. She is a certified immigration attorney who I've known for the past 8-9 years almost. She is the person who processed my own green card. And funny story, some people know this, some people don't. But I actually got rejected for my green card from USCIS. And I was pretty nervous as to what exactly I was going to do next. We were thinking about selling our home and moving out here.
Oh,
and
you
then
panicked.
yes, in the very last minute, I was like, hey, Laureen is someone who is actually a very good attorney. So let me talk to her. And she kind of jumped into my case. And within a matter of days, refiled my application. And then USCIS gave me an approval. So we are joined by someone who's very competent. And it is my great pleasure to introduce to all of you guys. On that note, Laureen, the table is yours.
Well, thank you very much. Yes, so my office does all immigration. There's 4 attorneys in our office, and we tend to have what we call a general immigration law practice, which means that we practice everything from humanitarian, removal, defense, employment matters, family-based, a little bit of investment. It's not my favorite area, among other things, and a lot of student matters. So we work a great deal with students and early career people. So our offices are in Chicago, Milwaukee, and Austin, Texas. But like all service providers these days, physical offices don't mean a lot. And it's federal law, so we practice with everyone all over the country. But the majority of our work is in the Chicago metro area. So if we want to go on to the first slide, because we have a lot to cover, and as we all know, this is H1B season. So we need to address what is happening in the H1B front. So Anand, or whoever is responsible for the slide, let's move on from, my picture, which is probably old and needs to be replaced, to something that actually is about H1Bs. Anyone? Okay, great. So, well, that one's also just an introduction saying that we're going to focus today. And the reason why I asked to focus on this today is that the small business kind of challenge with H1Bs in general, the reason is probably many of you are working with companies that have limited experience with hiring foreign nationals. And maybe not because your industry is definitely more comfortable with it than other industries. But for the most part, you're probably working with smaller companies that don't have a dedicated immigration plan in place. So this makes it a little bit more challenging to navigate the H1B process because they're not as familiar, comfortable, or ready to do so. So just as an overview, fiscal year 2026, everyone thinks, what do you mean by we're still in 2025? This is true, but everything with immigration in terms of the release of visas every year is in October for the following year, basically. So the fiscal year starts in October for immigration processes. So that's why we have that October 1st start date that you can be on your H1B if you get it through the CAP program. And That's why it is the 2026 year. Registration period, it's starting soon, folks. March 6th through March 22nd. Registration is not that difficult, but we'll go over some of the red flags in a moment. But just so you know, if you want to understand how registration works, USCIS has 2 different webinars or videos on their website. One is for employers. The other one actually is for attorneys, and it's worth a look-see as well. So you can watch that and see what the steps are step by step. The selection notices, hopefully, fingers crossed, will be sent out by the end of March. No guarantee. Sometimes these can be a little bit fluid. And the notifications usually go out like over a weekend for a few days. We can get notifications, you know, in dribs and drabs for about 3 to 4 days. And then after that, we kind of know these are the people that got selected. And for now, you didn't get selected. And then a week or 2 later, you'll get the non-selection notification in your USCIS portal. Okay. Filing period, April 1st through June 30th. That's the longest that you have. It's supposed to be 90 days, but again, that we don't know exactly when 90 days after your notification. So, but since they don't know exactly when, they've just done this window of April 1st through June 30th to file your your I-129. If you miss it, you're done. Trust me, I know this from a very hard lesson about also checking the address that you are assigned to submit your H1B. Okay. And if you miss that window and something happens, the mail service, whatever, you're SOL. Okay. And then start date for approved petitions, as I said, October 1st. Quick practice, you know, tip, point, whatever. Don't immediately file for premium processing. Okay. You have until October 1st to wait, no matter what. Premium processing is expensive. You don't need to do it until you get closer to that October 1st deadline and you don't want to have any interruption in employment authorization. Do it in August. Why pay the government more money than necessary until you actually need to pay them more money? Okay, so that's just a practice tip. Red flags. Okay, just so you know, by the way, the fee for registering H1B went up from what, $10 to now like $225. Okay, there's a reason for this. Fraud was rampant. We've now had this process of the lottery for H1Bs for a couple of years now, right? Before that, we prepared the whole H1B filing, and the filing itself went into the lottery, and you were chosen based on that, and then they adjudicated it. Then they changed it, and it was better for applicants. It's better for businesses. It's better for USCIS. It's better for beneficiaries. The only people that lose out on this is actually attorneys, because we build you for the work ahead of time in completing the filing, and then all of a sudden we have fewer. Some of us are very, very grateful for this because it makes for a much easier H1B season. Others, you know, this is their bread and butter, and they liked having all those filings, whether you got chosen or not. But that's beside the point. The fee has increased, and I think it's a good thing, because now if you look at the numbers from the go back to the red, go back to the yeah, no, you're going forward, go back. There, stay there. The reason why this is a good thing is that fewer people will be applying. You won't just have you know, random people just saying, hey, why not? Let's try it. You won't have multiple filings. One of the things that the first year we had problems with is that companies were filing multiple applications for the same person. That got resolved. That wasn't good. The next year, what we had was one person getting multiply filed by different employers. That can still happen technically. So for instance, employment agencies that people will sign up for, they will submit them into the lottery. Well, that person could sign up for 10 agencies to submit them into the lottery. What does that do? That bumps up all the numbers, gives them a higher chance. And if you're only paying $10 plus whatever the agency fee was or whatnot to register for the lottery, it made sense. Now with the increase in fee, it's going to downplay all of these multiple entries just for the heck of it and things like that. The people that will be entering now should be more serious about pursuing the H-1B and not just doing it for anything. Incomplete applications is a huge issue. Missing the required documentations when you file for the lottery. Filing for the lottery is relatively straightforward. It's just that if you don't do it right, it's done. You failed. And anything that is a misrepresentation, again, going back to if someone files twice, you're out, you're kicked out, you're done. So if whoever is registering you an employer, let's say they have their admin do it in the office, and the admin messes up and then decides, oh, I'll retry it with a new email, and then she gets you submitted twice with the same employer because of the employee ID number, you're kicked out. Both applications are done. So things like that are a problem. We don't vet the people that we submit initially. In other words, if someone comes to us and says, I have an employee I want to file the H-1B for, and they tell me that they're doing work as an engineer, I'll go ahead and file it without getting their qualifications, because that's what I'm getting filed to do. I depend upon the employer understanding that it's specialized employment. If later on I find out that the person doesn't have a degree and I can't even use, their experience enough to get them to that degree level, they're out of luck too. So you have to make sure that it really is specialty. And again, missing any of the deadlines. So now let's move on. Next slide. Okay, so here's another issue that I see as problematic for smaller employers and even some big employers. All employers have budgets that they need to rely on when it comes to hiring in general, and then what they consider their budgets for employees overall. Okay, so a hiring budget, an employee maintenance, maintaining their workforce budget. I see immigration benefits and the costs associated with them the same way that I see health benefits or retirement benefits. But most employers have not made that switch in their head. Okay, they see this as something that is special just for their foreign national employees. So they have a problem acknowledging that it is just another benefit of employing someone. They also fail to consider the cost of attrition and recruitment when it comes to filling spots. So let's say they have someone that has been working for them on STEM OPT for the past 2 years, and you go to them and say, hey, I want to file, I need you to file an H-1B for me, and they start pricing this out, and they're shocked at the filing fees, the costs of legal fees, and maybe the premium processing fee, and they're like, I can't do this. But what they fail to calculate is how much it costs to recruit and train a new person for the job. So that is where you, as the foreign national, has some leverage, okay? You want to really try to make sure that they understand the real cost of not pursuing the H-1B on your behalf? How much does it cost for them to recruit? How much does it cost for them to interview? How much does it cost for them to hire and train and get that person up to the speed that you are after 2 years of employment with the company? And that is the real cost of whether or not someone should or shouldn't proceed with an H-1B visa on behalf of their employee. So that's something that as you're having these discussions and you want to advocate for yourself to have the employer file, that you need to be able to show them the budgetary costs of this. There are lots of places online and studies and things like that where you can find these costs. And if you get pushback, this is where you want to bring it to. If you have an actual HR department, they'll be better, they'll acknowledge better these types of costs and we'll be able to help you with that. But if you are dealing with an employer that doesn't even have an HR department, you're going to have to work on that yourself. But these are some of the things that I see as a challenge that happens this time of year as employers are trying to decide, should I or shouldn't I? And they see these price tags and they get a little sticker shock and they don't really understand what they're investing in terms of long-term benefits. Okay, so let's move on to the next slide. Okay, so this is everyone's nightmare, right? You didn't get accepted into the H-1B lottery. You didn't get a spot. So if you got the spot, you filed timely, you got your approval before October 1st, you're all good. The only thing you have to worry about is working with your immigration attorney or whoever is doing your case to get you eventually a time to go out of country to get your new visa stamp, things like that. Update paperwork, who knows, doesn't matter. But you're sitting pretty because you got an H-1B and now you know that you potentially, assuming that your employer does a perm or you do an NIW, whatever the case might be, you're going to get a green card. And this was your plan for your career. Okay. But what happens if you don't? First question, of course, is, are you still on OPT? If you are, you're okay for at least 1 year, one more year. If you're not, and you have to start scrambling, these are the things that we look at in terms of, would you qualify? Can we do any of this? Day one CPT. Okay, now I know that a lot of people go to the University of Cumberland's for this. It's super easy and everything else. I'm going to tell you right now, though, USCIS is getting a little irritated with day one CPT. They see it as a loophole. They question the education, and the number of hours that you're putting into these master's programs and things like that. And they really, really scrutinize these cases because they think that they're being misused. Okay. New administration may scrutinize them even more. So be careful when you're looking at a program and you're trying to figure out how you wish to proceed. Really document why you chose the school, what your program is going to be, and demonstrate that you are doing everything that you should to maintain status, and that this isn't just for the purpose of employment authorization. Okay, you have to participate fully. And I suggest, rather than just going straight to those schools that say, we'll give you CPT on day one, and that's their whole reason for being, again, Cumberland, maybe look at schools that you'd rather attend and see if they're willing to issue you CPT, okay, as a part of the program itself. A lot of schools want you to take some time off from work while you're in your master's programs, but there are also schools, especially in MBA programs, that are happy to have you working for a company that is going to help elevate your studies. Okay, so be sure that you are careful as you're doing this. Okay, L1 visa. Nobody likes my my theory on L1 visas because I think it's because you all have this plan in place about what you want to do with your career, and you never thought of the L1 as an option. And now I'm giving you this whole loop, you know, something outside of your plan, and it throws you for a loop. Okay. Relocation. So just like some of you are with small companies that don't have large, you know, entities abroad or anything, some of you might be with companies that do have entities abroad, or you have an opportunity at a company that has a foreign national entity. You know, we don't know whether you're here with the company and it's for a transfer, you have the opportunity of employment at that other location. The thing about L's is that there's two types. There's the L1A, which is executive, and then there's the L1B, which is managerial, and it can be managerial and or specific to a process, managing a process, people versus process. Okay, the nice thing about the L1A, and this should take note for Chinese and Indian nationals, is that when you transfer and come back, if you are in L1A, you are EB1 for the green card without having to apply to show that you're exceptional. It's an automatic through this process. You just made your green card that much faster, that much easier, that much less expensive by going through this process of elevating your career for a year or two by going abroad. I mean, on top of it, maybe you get to go to someplace fabulous for a year or two. There's nothing that elevates a person's career faster than doing an assignment abroad. Okay, I look at a lot of career trajectories, and I can assure you that this is not taken lightly by companies, and they pick a lot of really great people to do these assignments, and it's a good opportunity. So, you know, if you worked for the US government and they decided to send you to, you know, some small country and left you there for, you know, to rot, yeah, that would be a downgrade in your career trajectory. But for the vast majority of people, this is the rocket to the top. Okay, so really, really think about that when you are considering whether or not that could be a part of a way to get to your end goal of, you know, permanent residency in the United States and career goals in general. So pursuing a higher degree, this is not necessarily the same day as day one CPT. This is simply, I didn't get the H1B. I didn't, you know, I didn't get chosen. I need to decide. I don't want to leave the United States. You know, I'm just going to go back to school for a while and see what happens and kind of start the whole process over again after, with a master's degree or PhD or something like that. One thing I did not put in here, and I should have, is cap exempt H1B. I don't know how many of you are familiar with cap exempt H1Bs, but I bet some of you might even be employed with an entity right now that is cap exempt. For example, if you are employed by a government agency, probably cap exempt. If you are employed at a university, it's cap exempt. If you are employed at a hospital that is a nonprofit hospital, it's cap exempt. A school district, cap exempt. Those are great opportunities to avoid that lottery. Why are they cap exempt? Because they're nonprofit entities associated with a public university, okay? And I can guarantee that any school district, any nonprofit hospital, any government entity is associated with a nonprofit university. Don't worry about that part of it. That has some type of focus on education. Let's use the hospital for an example. If the hospital is a nonprofit hospital and they obviously hire doctors, residents from various universities, okay? There's going to be at least one that's at a public university. So they have perhaps a memo of understanding that they are educating these these doctors on their residency for the purpose of educating them. That qualifies for a CAP exempt H1B. School districts, student teachers, same thing. Government entities, they work with universities all the time, whether it's for programming of some sort or anything at all. They're going to have some kind of contract with the public university. All of those people are CAP exempt, as are the public universities themselves. You do not have to teach or do anything like that to qualify. If you are at the university and you are working in the engineering department, if you are working in the marketing department, whatever the case might be, you qualify for a CAP exempt H1B. Okay, so definitely something to consider. Public entities, nonprofits, CAP exempt. O1 visas, if you have the master's degree, seriously consider it. If you have something else that might be special, that you're doing, that you're working on, that you've achieved, then that also is something that you should consider doing to, buy you time or be the option. The nice thing about O1s is they don't necessarily have to be they don't necessarily have to be attached to an employer. There are ways to use a sponsor that is different than being attached to an employer. Okay, let's move on. Okay. This shouldn't have been in here. Let's move that one on again. I actually went through that on another day. So let's go to the next slide, please. Okay, so going back to some of these small business sponsorship challenges, financial capacity concerns, which I already talked to you about, and what I think, they should be considering when you're looking at it, but they're still going to be very concerned. They're going to be looking at the costs related to the fees, compliance expenses, maintaining their public access file, making sure that someone checks for ongoing compliance with maintaining the H1B, and then any kind of requests for evidence. We are already seeing an uptick in our RFEs. Having said that, just so you know, all an RFE is, a request for evidence, all it is communication with USCIS. RFEs are not some kind of, notice that your case is going to be denied. It's possible, but a notice of intent to deny is the real thing. It could give you a little bit of a hint that you have a problem, but really all an RFE is a communication. USCIS has no other means to communicate with us. It's just RFEs. They don't write us letters and say, hey, we got your application, let's chat about it. No, they send you an RFE, and it often is boilerplate language and scary and this whole list of stuff, and without any real explanations of what they're thinking, but this is the process. So don't freak out when you get an RFE. It's just the form of communication. Again, limited HR and legal resources. I have a lot of consultations with people that will be like, my employer told me to find an attorney so that we can do this. I have no problem with that, but just so you know, You are not my client in that scenario. There's a dual representation. I have a certain level of duty towards you, and I will maintain that. But in the end, the employer is going to be my client. They're the ones that get to decide whether or not to pursue the case. They're the ones that, you know, give me the certain information and decide how far we're going, how much they're going to pay, all these various things. They're my client. So you have to be careful with this. Even if the employer's like, I don't really want to, you know, get involved, but if you find someone, I'll do what I can. No, the employer is the client. The employer pays the fees. The employer does the work. Okay. So you have to be careful about this. In the end, they are the client. And that means if you have any concerns, you really shouldn't, you know, you really need to think about having your own attorney to discuss these things with. And just as an aside, this is really, really true if your employer works with one of these really large immigration factory type firms. Nothing against them. There are reasons they exist and they're good at what they do, but they're not going to have the time or authority to discuss concerns about you, okay, and about your future and your issues, okay? They're not going to sit down and chat about how your spouse is on an H4 and you need to get them into a status where they will get employment authorization as quickly as possible. They're not going to really be all that concerned about the fact that if you don't get your perm filed by such and such date, that you're going to not be able to extend beyond your 6th year. That's not what those firms necessarily do, and that's not how they work. So you really want to consider that when you're thinking about, you know, the limitations of HR and legal resources and things like that, that you might want to have your own attorney to discuss these things with, have a consultation with, and be able to answer questions and be advised on what's best for you, not what's best for the company. This kind of goes along those that thought process that HR is not about you. HR is to protect the company. Same thing here to a certain extent. Okay. So the immigration attorney is hired by the company to protect and advise the company, not you. Again, a little bit of dual representation. And if we see a conflict where we have to harm one versus the other, we pull out. But that's something that you have to be aware of. Misunderstanding the real cost of hiring, which is what I was talking about before. Making sure that they understand what they're really investing in and what their costs would be if they don't invest in you as the foreign national. Okay, so that's, I mean, I really can't overemphasize that when an employer comes back and says, oh no, this is too expensive, this is a lot of money. And then they ask me, can I make the employee pay for this? And I'm like, no, you can't make the employee pay for this. It's a cost of doing business. Okay. Okay, let's move on. Okay, so, and this has gone faster than what I expected, so we'll have a lot of time to chat. Is that I am sure you are all freaking out right at the moment. I'm freaking out. Everyone is freaking out, right? It doesn't matter if you're an employer, if you're an employee, if you are here as a student on a work visa, or if you've applied for some type of humanitarian relief. Maybe you're DACA, maybe you're TPS, maybe you're on asylum application, not decided yet. It all is super confusing, and we don't know what's happening from one day to the next. And I do not have a crystal ball. Okay. So, all we're, you know, as immigration attorneys, we're just doing our best to try to keep up with the madness. But a few things that we have determined for sure. Birthright citizenship not going to be withdrawn. Okay, they can try, they can try, they can try. Incompetence of the and misunderstanding of the law and the Constitution is what fueled this executive order, and an executive order does not override the Constitution. Okay, there is belief that the Constitution has been inappropriately interpreted in terms of granting citizenship, birthright citizenship, but that is also what we call stare decisis, or jurisprudence, historical jurisprudence and case law and all the things that we can rely on, and don't see it happening. And as of right now, it's not. Are there going to be places that don't know what to do about this, like hospitals and communities, whether or not they should issue birth certificates? I imagine. But if that happens to you, if that happens to a child that you have born here or whatever, be sure to reach out to someone. The ACLU is on this, as are some immigration attorneys that are drafting class action lawsuits and things like that. I don't really get involved in those things, but I can certainly send you to the right person if this type of issue comes up. Let us know. But we don't see this as a major issue moving forward. Okay, travel concerns. I'm much more interested in travel concerns and seeing that as a potential problem. First and foremost, country of origin. I mean, we are very familiar with country of origin travel bans from the previous time that this Trump administration was in the House, or in the White House. And we anticipate that they'll do it again, that there will be more travel bans. Years ago, when I first started practicing, there was something called NSEERS. It was a registry for people from certain countries. It was, it occurred during the Iraq War. I think that they've already tested the waters for some registry type things, people getting called in. Students could be, this could be a problem for students and things of that nature. It was the last time. So we are monitoring that, but travel would make that more problematic. Anyone whose case has been that is pending, I would not recommend traveling while your case is pending. We've been getting reports of people leaving the country and then their case getting denied while they're gone and then not being able to re-enter. So that is definitely an issue. Making sure that you maintain a passport with the necessary amount of time on it. Do not allow your passport to get to, less than 6 months. In fact, if your passport has, around a year, I would start planning on renewing it and keeping it renewed appropriately. Okay. If you're from a country that requires you to return your passport while you are renewing it, if there's an expedite fee, we recommend that you pay it and that you get it back as quickly as possible. Okay. You need to make sure that you understand if you are going to travel, what your status really is. For example, if you're on an H1B and you've also applied for adjustment of status, which status are you going to re-enter the country in? Remember, every time that you present yourself at the border, you are an arriving alien. Okay. What does an arriving alien mean? It means that you have less rights than someone that's already physically in the country. Okay. So, for example, you have not been admitted at that point. And if they decide that you are inadmissible at the border, they can deny your entry for for whatever reason. You got a DUI, even just basic arrests, things like that. Lake and Riley Act is literally just requires a suspicion of certain things. So keep that in mind and make sure that you are talking to an attorney. And if you have a criminal matter, make sure that you're not just talking to the criminal attorney. Never, ever, ever accept any kind of agreement, plea, whatever. I don't care for what kind of issue it is, unless you've talked to an immigration attorney before you do so, okay? Criminal attorneys, unless they equally practice immigration, which there are plenty out there that do, you need to talk to them about, you need to talk to an immigration attorney. I would also say, remember, not all immigration attorneys practice all areas of immigration, okay? So if your immigration attorney only knows employment matters, you need to make sure that you're talking to an immigration attorney that understands removal matters. If you have had any kind of issue, inadmissibility, again, that means that you're out of the country and you're seeking admission and they decide that they don't have to let you in because of something, okay? That's different than deportability. So these are things that you have to make sure that you're talking to the right people for the right issue, okay? So those are the things I would have concerns about travel. If you're on advanced parole, make sure that you know that your case isn't going to be decided anytime soon and have that as an issue and things like that. Changes in processing times. Just don't believe anything that's on the USCIS website when it comes to processing times, because it's just, one day I will look and it'll tell me that something is, 16 months. 2 days later, it'll tell me it's 48 months. I have no idea what, is it an algorithm? Is someone actually, entering these times on occasion? Is there I have no idea. All I know is, it just isn't helpful, and don't rely on anything that, USCIS says. In my opinion, the reason why the timelines are so high is because you're not allowed to do an inquiry until it's outside normal processing times. So if they say normal processing times is 36 months, we're not allowed to inquire on the state of the case because it's still within normal processing times. See the beauty of that? If they decide that they're so incompetent that they need all this amount of time to decide something, they'll put all that time in there so that you won't bother them. Okay. Increased requests for evidence. As I said, we are already seeing this. I mean, really weird, stupid inquiries and RFE responses. And then we're seeing various policy changes. You may or may not remember, had ever known, but in the last administration, one of their weird things that they required was if a question did not apply to you, that you had to put NA in the boxes, in every single box. And if you didn't put NA, they rejected your case or they denied it. These are arbitrary, stupid type of things, but it's a way to eliminate their need to do the work. And, yeah. The good thing I will say is USCIS and most things regarding immigration are self-funded. This is why the fees can keep increasing, and I won't be surprised if there's not another increase. So hopefully, fingers crossed, that means that they won't fire a bunch of immigration officers, but not hard to say. I don't know what's going on with that. Because we already have such incredible delays on certain case types that if we fire more people, really, they're just trying, it's just a matter of making it all the more painful, right? I also do not see any light at the end of the tunnel when it comes to visa numbers. I used to be able to do a perm for someone in other worker EB3, and by the time I got through with the Department of Labor, except for India and China, we could file the green card application. Now, my people are still waiting another 2 to 3 years after completing the case with the Department of Labor. And I don't know, unless people decide that they don't want to move to the United States, that is just going to continue to increase because we're a global society working on a 1980s, plan for immigration. And it's just, that's that. So anyhow, questions, concerns, what do we got?
Perfect. So we got a few questions in the chat box, but before I start that, I want to first say thanks a lot for explaining the dichotomy which the immigration lawyers have, similar to HR. A personal incident was after my I-140 was denied, I hired my own lawyer just to make sure that I identify what was the mistake that actually happened, so that then I can use the right lawyer. So before I spoke to you, I did exactly that, and these attorneys cost like $400 an hour. No. So you do have to pay out of pocket because that's how you actually get attorney-client privilege. So you want to make sure that you are the person who is hiring the lawyer if you have any questions. So
And I want to point out that attorney-client privilege issue is a huge one. If you have something, let's say for instance, you got a DUI, okay? Don't bring that to me as your employer's immigration attorney, because now you know I have a duty to potentially bring that to your employer because it could negatively impact the case, okay? Take it to another immigration attorney, please, for the love of God. I'll give you a name. Don't, we want you to have attorney-client privilege with someone that even that immigration attorney might call me and say, hey, we have a problem. I'm not going to tell you what the problem is, but you need to get this person consular processed as quickly as possible so that we can get their visa stamp back in and get them into the country. And I'll be like, I trust you. I will do this right away for them then. That's the advice. Let's get this ball rolling. And then later on, they're going to take care of the other issue that I don't want to know about. Okay. So yeah, very important. It's worth the money because it's about your future.
perfect. Well said, Lauren. Thank you. And we have a few more questions now. Let me start with the first question. Omer asks this question saying, do all master's graduate qualify for the O1 visa?
Technically, yes. I mean, a master's is one of the, if you look at the USCIS website, and they'll have the O1 as what are the things that they're looking for. But an O1 isn't just about having a master's degree, right? There's various criteria on there, and various things related to being exceptional and what makes you exceptional and things of that nature. So my suggestion is, if you're interested in the O1, take a look at the criteria and see how many of those boxes can you check. And then if you have any questions, do I check this box? Or can an attorney make the argument that I check this box? Do that. And just so you know, once again, I've said this before with NIWs and EB1s and O1s, don't create manufactured media about yourself. It's a losing criteria every single time. And I could make phone calls today and create all kinds of media for myself. Was that real? No, it's pay for play, and pay for play. USCIS knows all of it. It does not work. Don't do it.
Okay, great. Second question that we have from Shubham is, how can an employer start the perm process while the employee is on a CPT? Is that even possible?
You can start the perm process if the person has never stepped foot in the United States. They don't, perm is about the employer testing the job market and making an argument that there is no US-based employee available for them to hire. So it's not about you, it's about them, until we get to the part where they say, okay, I've identified a foreign national employee that I can hire, and they have the qualifications. The qualifications don't have to be with that employer. And in fact, it can't always be. Let's say that you got all of your experience as an engineer with that employer, and the employer wants to say 3 years of experience. You don't qualify. You have to have gotten the experience either with another employer or this employer, but it's a different job. So now the employer would have to say, okay, I want to make you the project manager of engineers, and 51% of your job duties are different. Then we can count the 3 years of experience that you got with that employer. So in reality, it has nothing to do with you working for the employer. It has to do with the employer finding the right employee to hire.
Okay, I had a quick follow-up then. I was under the impression that you need to be on a H1B visa for you to get an approved I-140.
Yeah, you have to be in maintaining status. And in fact, this wouldn't apply to any of you, most likely, fingers crossed. I get I-140s for people out of status all the time. First of all, F1 students don't accumulate unlawful presence. So if you fall out of status and you start working, and then your employer says, hey, I'll help you, I will file a perm for you, but I have to consular process you, because you cannot adjust status in the United States when you're out of status. But because you were in F1 or J1, you don't accumulate unlawful presence. So the second you leave, you don't have that 10-year bar to come back. You don't need a waiver or anything. So you can go to the consulate, get your green card, and come back. So no, you don't need any status technically. Again, you don't have to work for anyone. You don't need a status. You can have whatever status. I help people that are, that come here under asylum applications, right? They come and I've had PhDs on asylum, and then they get jobs here, and I'm like, oh, let's do a perm, because asylum's probably going to take the next 15 to 20 years to get anyway. Let's do an 01 to NIW and get you a green card, and forget that that very speculative asylum case, even if it's a great one because you were the nuclear scientist for Iraq. But the point is that employment's always going to be easier in a lot of situations, and you don't have to have any specific status at all to do a perm. Perm is completely independent of any employer. You could be working for one employer and another employer says, hey, in the future, we'd hire you. We'll petition you for a green card, but we're not going to hire you until you have a green card. Okay.
Got it. Okay, that's good to know. That's good clarity. Because a lot of people assume that you need to have a H1B for the perm as well as H140. Yeah.
Here's a scenario. I had a friend who was a speech language pathologist, worked for a big hospital, but the hospital had a hiring freeze and wasn't doing perms. She had a friend with a teeny tiny little practice. The friend said, I can't afford you right now, but I'll go through the perm process with you and we'll do that. And then once you have your green card, you can bring in clients and things like that. I don't have to support your salary. So let's do that. And she got her green card through that process, working for the hospital the whole time until it was time for the small, tiny little practice to hire her with her green card, and had her clients come with her.
Okay, that makes sense. The next question is by Gabriella. I think this is an easy one. Can you please repeat what option I have if I get the H1B and not get selected for the visa? I'm assuming maybe perhaps I can answer this. H1B is the visa.
Yeah.
So yeah.
Let me clarify something. There are non-immigrant visas and there are immigrant visas. Everyone in the United States is supposed to be on a visa. The question is, where does it stop and start? If it is a non-immigrant visa, okay, it might have a number of years that it limits you to, and it might start October 1st with the H1B, or maybe it starts whenever on a rolling number with an O1 or cap exempt H1B, but it ends on the number of limitations of the visa itself that you're allowed to have. An immigrant visa is your ticket to apply for a green card. And you are allowed to apply for that green card once your visa has been approved and you're at the front of the line. Remember, if you're from India or China or the Philippines, your line is a lot longer. Okay, and that's the challenge there. But yeah, everyone has a visa, or should, or they're on asylum or something, you know, that's slightly different, that is different from a visa, but still authorized to be here.
Got it. Okay. Next question we have is from Juan Chang Liu. What she's asking is, if she has a child born and she has applied for the H1B, would she be considered to immigrate, and USCIS can deny her non-immigrant H1B petition for the lottery, or does having a child have any bearing at all?
Shouldn't have any bearing at all. Yeah, I mean, it should not have any bearing at all. I mean, here's the thing, folks. What some people in the government are upset about mostly, I think, is this idea that people have children for the purpose of immigration benefits. Okay, there are even travel agencies out there that create birth tours and stuff like that. Is there potentially a little bit of abuse of countries that have birthplace citizenship and trying to shop around citizenship? Maybe. Who cares? It's not that big of a problem, in my opinion. And I have, you know, whatever, screw it. But for anyone that is residing in the United States on a student visa, H1B or anything, just don't even worry about it at this point. Seriously, this is going to go, this will take years for this fight to be resolved. And by the time we get there, either the Republic will be gone or this administration will be. I'm sorry, I have very strong feelings. So anyway, that's, you know, just, yeah, don't worry about it. But if anyone gives you any pushback, again, reach out. ALA, ACLU, you know, whatever, you shouldn't have a problem.
Yeah, so have a child regardless of the administration is what I'm saying.
Apply for your children's passports. Okay, if your child does not have a passport, do it. Get the passport. Okay, don't wait. Keep it, maintain it properly. Get that passport.
Got it. Okay, so the next question is by Ali Kwabi. If this is regarding an asylum, how long shall the person need to wait before they can file an application for a green card if they're currently under asylum? Some say that there is no need to wait a year. Is there a benefit for waiting one way or another?
There is actually now a process, but I'm not sure it's going to be continued, where you don't necessarily have to wait to file for the green card, but they'll hold your case in abeyance. Okay, technically you cannot become a permanent resident until 1 year after asylum. That doesn't mean that you can't apply. But that, you know, that changes by policies, and like it's more like a case management system. So for right now, you can still file it before the 1 year mark, but you won't get your green card before the 1 year mark.
Okay.
Because that's under law. That's not, you know, that's actual law. Policies are different than law. So, you know.
Okay. So we just passed one, but there's still a couple more questions. Are you okay if I ask you?
I'm fine. Go ahead.
Okay. If someone wants to leave and they have a hard deadline, they can leave, and we can send the video to everyone. So I wouldn't worry about that. So the question by Rishu Thakur is, how expensive is it to get a lawyer? What are the hourly rates?
Lawyer fees are going to increase. I'm sorry. You know, I wish I could keep my fees where they have been, but my staff is already, it's just, fees are going to increase. So immigration attorneys are unique in that we do a lot of our work on flat fees. I don't know why. If it's someone like me, I have raging ADHD and I wouldn't ever properly bill you, which might be a good thing for you. But you know, it also, and I think the hourly billing model should die a slow and painful death in general, because probably some of you understand this too. It's not good for those of us that are efficient. That surprisingly enough, I'm super efficient at my work otherwise. And are experts in our field, right? So we do a lot of flat fee billing, but generally speaking, attorneys these days for immigration are around $300 an hour in fees, up and up, okay, which is market rate. There are plenty of attorneys in smaller markets that will charge less. And remember that immigration is a federal process. You can have an attorney anywhere throughout the country. I know immigration attorneys that live outside of the country. And some of these attorneys that do things like O1s and EB1s, they're totally solos. And so they're only paying themselves. And they just, they plug away at these cases, and their fees are going to probably be pretty darn good in general for what you're getting. I think one of the things that you have to consider is, what are you investing in? Kind of like the employer, comment that I said. How much does it cost not to do this? Okay. And I think that's one of the things that you have to consider. If it's like the O1 and you know that you could get a sponsor and it allows you to have real flexibility in your employment and the ability to take on extra projects and various things like that, and increases your income, well, the investment in that attorney might be a really good idea for you, even though it seems shocking. One of the things that my office does when we send out any contract is we send out a list of financiers for immigration expenses. These are credit unions, nonprofits, and various other entities that finance the costs associated with immigration. My office had to stop doing a lot of payment plans because, we're all bleeding heart liberals here in immigration world. And I just couldn't survive any longer with, clients that paid me $50 a month for the next 10 years. But you're going to see a large expanse of this, but I would say roughly you're looking at $300 an hour.
Okay, that sounds good.
Yeah.
Shoaib Khan.
It's going to cost you at least $15,000 to get a green card. Put it that way. That is probably base amount of money to get a green card is 15 grand if you have an attorney. So including your filing fees, but that's probably family. So it's just going to keep raising for everything else.
Got it. The next question we have is from Shoaib Khan. This is regarding the cap exempt H1B that you mentioned earlier. Is there a waiting period for H1B for the nonprofit agencies? And a follow-up is that are state agencies like Illinois DOT perhaps, or any other state agency, are they also considered a nonprofit for this purpose?
Yes, anything government. I love cap exempt H1Bs. When someone comes to me and they're like, I work at XYZ, language school as a teacher, I get so excited. I recently had someone that came to me from the Greek Archdiocese, and someone had filed an O1 for her, and it might have been approvable, but it had an awful RFE. I'm like, why are we putting ourselves through this? We got an H1B approved in like 3 days with no RFE for the same job. So these are great to submit. And like I said, there is not a nonprofit or government entity out there that doesn't have some kind of relationship with a public university, whether it's because of their student teachers, whether it's because of, some program that they put on for, elementary school students. I don't care. They do something. And they're great. By the way, you don't have to stay at the nonprofit. You can transfer to another private entity employer at a later date, and it
Right.
doesn't count against the cap, and you don't have to stay at that with that nonprofit employer.
That's a nice loophole. I didn't realize that.
It is a nice
So
little loophole.
then here's the follow-up on that, if you don't mind. So say, for example, someone's married here, right? They are both F1 students, for example. One person who's, I guess, the dependent is applying for this non-cap H1B and gets it because their undergraduate is from a relevant degree. Can the other person who is on F1 right now work as a H4 because of the EAD that we have?
Not until they file an I-140.
Got it.
But that's when you can file that national interest waiver and get that H4 EAD status. And that NIW probably isn't going to be adjudicated for a few years if you don't premium process, 2 years perhaps. And that buys you some time to figure out everything else. And now you also have extended your H1B beyond the 6-year cap.
Wow, that's a really good loophole. I'm really glad you talked about it. Thank you.
Let's not call these loopholes. Let's
Sorry.
just call them strategies
Your
because
strategy. Sorry, I apologize.
yeah.
So the last question I guess we have is from Rishu Thakur. What different services typically will an attorney provide if they're consultant independently, apart from their employer?
Well, it depends upon what you need, right? Let's say if it's just a matter of a consultation for the purpose of making sure that you're, they're handling your case the right way or something like that. Or you might come to me and say, my employer didn't agree to do a perm. I'm on H1B, let's figure out, are you eligible for an NIW? Are you EB1 material? How could you become NIW or EB1 material? We do a lot of strategy sessions on what your future options are in that regard. We talk about, they want to know, for instance, their employer did do a perm, but they don't want to stay with that employer. What's going to happen to that perm? That might not be something that they want to discuss with their employer's attorney, who would then turn around and say, hey, Shweta just had a call with me to discuss leaving your employment. They may or may not. It depends upon where they see their loyalty and their duty, but it's a possibility.
Okay. I guess we've got a couple more questions that came in, if you don't mind. The first one is from Gabriella. What is the chance to get selected for a H1B if they have an MS degree in STEM, like a master's degree in STEM?
I forget how many we have for, I think it's 10 to 15,000.
20,000 is what I remember.
Yeah, okay.
65 and 20.
The real point is, we won't know your actual chances until we know how many people apply, right? It's math. But beyond that, you get 2 bites at the apple. Basically, they do the master's draw first, and then if you don't get chosen in the master's, you're put into the general lottery pool. So 2 chances, and there's 80 some visas available annually.
Okay. The last question we have is from AD. How can you switch from a cap exempt H1B to a regular H1B?
Well, you're not really switching. You're just switching jobs, just like you would any other. So if you got a job and it was through like a university, for instance, and then you get an offer at a private entity, the private entity transfers the visa like they would any other visa. It doesn't matter. Once you have your H1B, you have your H1B, whether you got it in the cap or if you got it cap exempt.
So you just apply for H1B transfer is what I say.
Right.
Got it. Okay. Looks like that's all the questions we have. Thanks a lot, Laureen. Any closing remarks from your side?
No, just be creative. This time of year gives people anxiety that they're not going to get chosen for the lottery. And I would say if you don't get chosen with the lottery, make an appointment to see an immigration attorney and come up with a new strategy. And don't be myopic in what your plans are. You have to be willing to, you know, roll with the punches here and really determine what your goal is. Some people, their goal truly is they want that green card. That's it. That's the only goal that they have. But for others, it's, you know, it's a career goal and things of that nature. So you want to make sure that you are really trying to figure out what you're willing to do to achieve your goals. And maybe sometimes you have to reassess what those goals should be, okay? Because U.S. immigration law is not going to take you personally into account. And honestly, U.S. immigration law is ancient and antiquated. And I mean, countries like Portugal and Spain already have nomad visas and things like that. These other places that are beautiful and lovely to live in have already figured this out. And we're still here arguing about, you know, border policy and not really taking into account what the country needs to continue to achieve. We also no longer believe in science. So there you go. You guys are all engineers. You're screwed either way. So so with all that being said, be open-minded, think outside of the box, talk to an attorney that thinks outside of the box. Make sure that when you talk to an attorney that thinks outside the box, that they understand the whole picture of immigration law, because I'm sure some of you might come from countries that maybe you shouldn't be returning to. But that attorney might not think of that in terms of what other options you have. I might say to you, awesome, let's do an asylum application because you didn't get H1B, and then let's have your employer start a perm process, or let's start an NIW, right? I maintained your status because now you've filed for asylum, no unlawful presence, and we've come up with a long-term solution towards a green card. So that's not going to occur to all immigration attorneys if they don't do a broad spectrum of cases. So that's also, our attorneys are going to talk to you about things like T visas, which are trafficking. You'd be surprised how many people are working in very legitimate employment situations and come to find out their employers violated the terms so badly that this person's literally been trafficked for the purpose of employment. So, I mean, those are things that we recognize, and lots of attorneys do. I'm not trying to say that it's just about us. I'm just saying, be careful about who you choose to represent you or to have these discussions with, because not every attorney is familiar enough with how to marry the different types of law together to come up with the solution that you want.
Okay, thanks a lot, Laureen. Really appreciate your time. And I wanted to say a quick word. We're able to do these sessions just because, you know, we have a good professional member as well as a corporate member base. So thanks to all the audience for being, you know, a member of our organization, because without you guys telling us saying, hey, this is actually good, we wouldn't know, you know. So thanks a lot for being a member and voicing your opinions. So we really appreciate your time. Thanks again, everyone. Bye-bye.
Thank you. Bye-bye.